Hey everybody, welcome to American Courts. You saw that promo there at the beginning. We made a GoFundMe setup for Lena's, trying to get her to Houston. Kathy's going to be able to go meet Judge Fleischer on October 15th. Let's see if we can get Lena's there too. If you can help, go to the GoFundMe thing and help her. Everything there goes to her account, and everything there goes to her. There's no middleman other than GoFundMe. You know, they always get their piece. But make sure to see if you can help out there. If nothing else, just root her on and send it to anybody that you think might be willing to help. We've got Judge Hayward, personal favorite of mine. We've got some Judge Boyd. We've actually got the recusal hearing for when Judge Boyd may be off the case, or she is off the case, but we'll look at that in a few minutes. We're going to jump over to Judge Hayward first.
Or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right, you can put your hand down. Mr. McDowell, you're before the court on State of Georgia versus Mr. Devon McDowell, 2024 CR 07616 for abandonment. You're represented by the law firm of Lister, Holton, Dennis. Mr. Taz Taylor is with you. Mr. Taylor, what is your client plead to the offense of abandonment?
Your Honor, my client is pleading guilty at this time.
All right, factual basis and recommendation, please.
Yes, Your Honor. On or about August the 7th of 2024, Ms. Withers did take out a state warrant for abandonment against the defendant. Pursuant to the warrant, the defendant willfully and voluntarily left his minor child in a dependent condition by failing to furnish sufficient food, clothing, shelter, or medical care for a period of 3 months. The affiant, Ms. Withers, is the aunt of the minor child. Your Honor, the state's recommendation at this time is 12 months to serve, 48 days, balance suspended, and under the special sentencing provision of OCGA section 19-10-1J, the sentence will be suspended until the victim turns 18. We're also asking for, pursuant to Ms. Withers, we're requesting no contact with the minor child, as well as no contact with Ms. Withers. And she is also on the line and wishes to give a victim impact statement as well.
I will say, Your Honor, that the no contact provision between Mr. McDowell and his son was not presented to the defense prior to just now. Mr. McDowell had been caring for his son. The mother of his son is in prison, so the son has been in Mr. McDowell's custody due to housing situations. Mr. McDowell recognized that he may be better off living with his aunt, who is the mother of the child's sister, and he voluntarily relinquished custody. I don't know if that's in a legal fashion or just go with his aunt. I do want the judge and the court to take this into consideration, that he has been providing for his son and been the sole support, but understanding the situation and what's best for his son and his son's education, which his aunt would be better able to provide him a stable housing location, which meant a stable school environment as well. He voluntarily did that. So we understand his aunt is concerned about monies being provided while she's taking care of the son. However, we don't feel that Mr. McDowell's done anything inappropriate that would cause no contact provision to be.
I did like 5:30 to the.
Hold on, Mr. McDowell. Let me hear Ms. Withers. Ms. Withers, I need to see you and hear you, please.
Yes, ma'am, I'm here.
All right. Let's see. All right. So Ms. Withers, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right, you can put your hand down. So Ms. Withers, abandonment cases are kind of unique in the sense that we're criminalizing a parent's failure to care for their minor child. So usually what is not a part of it is a no contact provision, because we're usually begging them to have contact with their child to provide the intangible support, not money, but things like emotional support and, you know, the love and care that a parent is supposed to have for their child. Um, Tell me your views on this situation, and I know the dynamics are um, kind of extreme in the sense that your sister is serving time, and then now um, Mr. McDowell has indicated that he has issues that make him unable to care for a 13-year-old son. Is it?
He's 12. He'll be 13 in October.
Okay.
Yes.
All right. So tell me what's going on, Swoosh.
Yes, ma'am. Well, good afternoon, and thank you for Your Honor for allowing me to speak on behalf of myself and my nephew. And since Josiah may not be allowed to speak, although I have him in the other room in case he needs to, I will gladly speak up for him. Your Honor, I have taken care of Josiah since the day he was born. I was at the hospital, picked out his name. I've been caring for him for all of his life, whether that was providing necessities for him that his parents could not give him or being there for guidance and support. I've helped with schoolwork, went to all his graduations, been there for birthdays, holidays, while they were in and out of jail or absent, and kept him for several years without receiving any financial support or emotional support from his parents. And to be clear, Josiah was physically under Devon McDowell's custody, at least for the last 2 years or so. But I would get Josiah every other weekend, all of his school breaks, and for the entire summer. And during all of that time, Devon McDowell barely reached out to speak to him nor check up on him. I went to his graduation for 5th grade, and although Devon McDowell lived within 10 minutes walking distance, he didn't show up. He refused to show up. After moving in with me, this most recent time, Josiah has informed me of several negative occurrences, one being that he was mentally abused or bullied almost daily by Devon McDowell, and he was also physically abused. And Josiah has told me of an incident that his father, the person that's supposed to take care of him and provide a safe space, he put a pillow over his head in attempts to get rid of my nephew. And because I believe that Josiah was simply too much of a burden for him to have around, I say those accusations are allegedly simply because we're in court. But I didn't see it with my own eyes, but I don't believe my nephew would lie about something like that. My nephew also informed me that Devon McDowell has told him several times that it would be better for his family with his current girlfriend, who also abused him, and her 2 kids if Josiah was not around. So I wasn't surprised when the police contacted me several times one day to inform me that Josiah was in an unsafe environment. It was a flooded basement. He was left alone several times, to the point where even the other people living in that house threatened to call the police on Devon McDowell for leaving him alone down there, and I needed to get him. This is what the police told me. And I say that I'm not surprised because Devon had been trying over a year to convince me to take Josiah and just put him on child support so that he wouldn't have to deal with him. And Josiah has lived with other people, including strangers in the neighborhood, that he paid to stay with them.
I have this thought theory, and it's just my theory, that one of the most important things for a developing child, especially in the adolescent age range, is stability. And it seems that this young man has had a very serious lack of stability. How is he doing in school? How is he doing from your standpoint emotionally?
In school, Josiah's always excelled in school. He's always been on the honor roll and everything. As far as emotionally, I don't think he's doing that well. He doesn't really, even when he told me about the incident, it was so, he said it in such a calm manner, like it was shocking to me. I'm sorry?
Disconnected, because a lot of times what happens is when people experience any form of trauma, then they have what's called disassociation, where they will recount it calmly to someone else because they're pulling away from it emotionally.
Yeah, it was just sad for me to hear it, So
Are you seeking any kind of legal relationship with with the young man beyond just having him in your care? Are you seeking a legal relationship with him?
Well, I'm going to court. I'm currently in court for the guardian ad litem, and I believe they're going to, I guess, determine if Josiah is going to live with me permanently with that guardianship. Um, as far as anything else, when Josiah was given to me, he offered and signed a power of attorney stating that he would pay $150 every 2 weeks for Josiah. His girlfriend sent me $100, I'm assuming on his behalf, one time, and then he was forced by the Honorable Judge Wright Hill to give me approximately $500 in July. He didn't show up for the next appearance to avoid paying the remaining amount. And I've had Josiah for over 6 months so far, and I've not received any support outside of that for him. And Judge Wright Hill also asked that he call Josiah directly, but he only called him like 3 times around the end of June and never heard from him again. And he was out during that time period. So,
So there's a pending case in juvenile court?
yes, ma'am.
Okay, all right. So anything else, Mr. Taylor? Any questions that you have for Ms. Withers?
I'm just a little confused to why she's trying to keep Mr. McDowell out of his son's life, and yet she's claiming that he's abandoning his son. It
Well,
looks like from
the two things they can happen at the same time. One, because based on her testimony, there seems to be a lack of stability.
Absolutely, we do not deny that there's a lack of stability, and that's why Mr. McDowell turned over custody of his son to his aunt, to the son.
But his son has also recounted some disturbing allegations that would constitute either neglect or abuse if proven. And so maybe that's why she's asking that he not have contact.
Well, certainly. However, those are allegations. This is the first I'm hearing of these allegations, and
Well, you expected Mr. McDowell to tell you?
Well, I don't exactly trust Ms. Withers to tell me accurately either.
Well, of the two of them, I think that Ms. Withers is the one who's showing up. And I hate to say it, but of the two of them, Mr. McDowell trusted her enough to take care of his child, because as you indicated, he willingly gave her the temporary, in whatever sense, custody of his child and trusted her to care for this child. And so
that's correct, Your Honor. I would suggest to the court that if the court's concerned about the young man's emotional well-being and growth, that his father remain in his life in some fashion. And
well, Mr. Taylor,
even if it's under the
having done this long enough and having done exclusively, I mean, having done abandonment as part of my jurisdiction as a magistrate court judge, I can tell you that sometimes a parent's presence is more disturbing to a child than their absence. And in that sense, I mean, if it's going to be a situation where it's a back and forth, a pulling, a pushing, statements or actions that make the child feel insecure or unwanted, then it is what the court deems is in the child's best interest that matters. And so in this case, because I'm not that deeply ingrained in the facts of this case, but from what I'm hearing, I don't think it's unreasonable to let the juvenile court make a determination about Mr. McDowell's role in this situation from the standpoint of the abandonment. It doesn't appear that he's been there. He may have turned this child over willingly, but he's entering a guilty plea. Ms. Withers has testified that he was made to pay $500 by Judge Wright Hill, that his girlfriend paid another $100, that, the police contacted her to come get this child out of a situation. And so I just would rather have the juvenile court make a more permanent decision, but with respect to what's being requested by me now, um, until the juvenile court makes a different decision, I'm fine with the no contact provision.
Your Honor, my concern is that your no contact provision with the sentence today will be used against Mr. McDowell at the juvenile courts. The reference book was a state court judge found it appropriate to assign Mr. McDowell a no contact provision in an abandonment sentence. Then who are we as the juvenile court to say that is an incorrect decision? We want to be consistent with the state court and would continue to impose such sentence rather than make it an independent determination. I just feel that Mr. McDowell supervised visits, I think would be acceptable. Supervision by
No,
Withers.
I'm not putting that burden on Ms. Withers, because that's a burden that comes with that there's some issues with supervised visits, because then I got to figure out who's going to supervise them, and if it's some third party that costs money, and he already is not paying, so I'm not going to impose that burden. This is what I will say. Does the young man have a phone, Ms. Withers?
Yes, ma'am. He has a phone. I gave Devon McDowell his direct phone number. That's why, as I stated previously, Judge Wright Hill told him that he should call him. He called him a total of 3 times and hasn't heard, Josiah hasn't heard from him in months.
All right, so this is what I will direct. Mr. McDowell, you can text the young man, which will leave a record. That is the contact that you are allowed to have with him, text messages only. And so these messages will be reviewable by the juvenile court, and the amount of messages, when those messages come in, whether they're positive or negative, those are all things that the juvenile court can review. Mr. Taylor's concern is that the juvenile court may just rubber stamp my decision. I know those judges, and they ain't scared of me. They have their own jurisdiction. And so I'm clear in my mind that they're not going to rubber stamp. But I will clearly, I will make it clear in this sentence that I will accept your plea of guilty. You're sentenced to 12 months to serve 48 days. The balance will be suspended as long as the only contact that you have with Josiah McDowell is by text message to the phone that he currently has and the number that you were previously given. Those text messages will be reviewable by the juvenile court, and the juvenile court can make whatever determination it feels appropriate for the continuation of any contact that they may order with the minor child. With respect to Ms. Withers, the only contact that you will have with Ms. Withers is to send money orders. So they can be Postal Service money orders or Western Union money orders, or wherever people get money orders that are reliable. The only contact you're to have with her is to send money orders in the amount of $150 every 2 weeks. If failure to send those money orders will put you in jeopardy of coming back before this court for failure to complete a suspended sentence. And sir, your sentence will be suspended and pending until such time as this child reaches the age of majority. The child is not yet 13. So that's a good 5 years that you and I are going to be talking about your care and concern for your minor child. Ms. McDowell, let me just tell you something. Kids don't ask to come here. Condoms are cheaper than child support or child care. And so when you bring a child into this world, you make the decision that you're going to work as hard as you possibly can. If I got to have 3 jobs, if I got to walk around clearing out people's garages and doing yard work, if I got to work 3 jobs at a time to care for the child that I brought into this world, then that's what I will do. But you can't rely on your girlfriend to pay for your child support. Your girlfriend has her own children, and she didn't lay down with the mother of this child and have a child. And so that is your responsibility. And so stay out of an orange jumpsuit, work as hard as you can get, even if you got to work 3 jobs to make sure that you pay for this child, and show him what a man looks like, Mr. McDowell, somebody who cares for the people that they bring into this world. You can't just give Miss Withers your child and say, well, I can't take care of him. I'm gonna give him over to you. Because you know what that says is that you're irresponsible. Um, when you bring a child into this world, your commitment is to that child as long as you are in this world. And so when a custodial parent, which Miss Withers is now the custodian of your child, she doesn't have the ability to say, well, I don't have it. I can't provide it, because then that would leave your child in the system. And you would have a fit if Miss Withers was like, well, I'm just going to kick him out on the street because I can't feed him today. But that's essentially what you're doing. You're not feeding your child. You don't know if he's eating every day. You don't know if he's going to school. You're not sitting down doing homework with him. When he gets sick, you're not up making sure he gets to a doctor. You are not doing any of those things that a father would do. You're not showing me father. And so when Mr. Taylor says, well, Judge, I don't think you should interrupt the relationship between a father and a son, you don't have one. Instead of buckling down and doing whatever it took to take care of this child, well, Miss Withers, I mean, you might as well take him. Thank you for that, though, because at least he's got a shot at growing up to be a child who is not mentally messed up. But get yourself together, sir. Get yourself together. Prove that you deserve to have him in your life. Because he sounds like a remarkable young man. With all the instability that y'all have, he's still a great student. He's still focused on getting the job done. Way more focused than you are. We clear? Have I made myself clear?
I'm clear on you, Your Honor, but last statement, you could let me talk, she's a liar.
Sir, the fact that you gave your son to her to take care of tells me that you probably need 2 more jobs than you got. We clear?
I'm clear with what you say, Your Honor.
All right. So do what you said you were gonna do and send that $150 every 2 weeks.
It ain't no problem. That's all she want anyway. She getting channel on it.
Well, you can talk jiggy with it if you want to, but you ain't showing me nothing. Show me. Show me that you're the man you're supposed to be. Show me that you're the father you're supposed to be. You can say anything. Most people do. But you're the one in an orange jumpsuit, sir, and she's taking care of your child. And until you can express to the juvenile court at least that you can take care of your child, you ain't doing nothing but talking. Talking loud and saying nothing. James Brown, check him out. All right, you can go back.
You gotta love the little comments that judge throws right there in the end. She does a dang good job of it. I really like that, Judge. I wish more were like it. We're gonna throw some Judge Boyd on. We're gonna show a real quick little. It was the beginning of a trial, and where she's giving the lawyer Goss, she's giving him some hell at the beginning, and then we're gonna jump to the recusal hearing that's making all the news lately. So we're gonna hear about 10 minutes first in a little beginning of a trial where she's giving him trouble, and then we'll go to that.
All right, court is calling 2022 CR 11862, State of Texas versus Alexander Castro. Can I have parties announced for the record for the state?
Daniel Escobar and Jason Garahan for the state of Texas.
For the defense?
Jasmine Olguin, Your Honor, and I would like for Mr. Jason Goss to be able to join the trial. We're requesting that with the court. Mr. Hillier is not present, as previously made aware of the court. He had to go out of the country.
All right, so he left to go on vacation. And so that the record can be clear, this was the date that parties chose. With regards to Mr. Goss sitting there, he hasn't been qualified for the jury. State, do you have any objections to him sitting?
Yes, Your Honor, the state objects to Mr. Goss sitting.
Your Honor, may I respond to that? I am his counsel of record. I have been entered as his counsel of record, and the state's right to not have me sit there does not supersede his constitutional right to have counsel and effective assistance of counsel, including counsel of his choice. Also,
Are you not here in the beginning during jury selection if you are his counsel of record?
Your Honor, I, along with Jay Norton, Nico LaHood, Patrick Ballantyne, Jasmine Olguin, and Gary Hillier are all his counsels. KK, I owe you an explanation there.
So Judge Boyd's mother gives her the purses, and she's able to, she has it to be able to think of her mom, to be able to remember her, and to kind of show her mom how much she loves her. Her mom watches her court every day. And so it's really important to her that she does that. And the flowers, it was brought up that uh, Judge Boyd's mom said that if you can't afford to buy, $20 worth of flowers for a week, what are you doing at that job? And that you're at that job more than you're at home. And so Judge Boyd buys the flowers and the purse is there as a gift from her mom. Basically, just Judge Boyd keeping close with her mom, and I think that's honorable. And so I think she did good. Uh-oh. Nan got me for geez, Bill, why spoil it? We're gonna have to figure this one out. So let's get there.
Record who have entered a notice of
My
appearance.
question is, why were you not present during jury selection? This is the first time that you have been a part of this jury trial. So my question is, why were you not present during jury selection? Why have you not been present during the state's case in chief? Why are you just now making an appearance?
Yes, Your Honor. So I had other matters that I had to attend to. This was Mr. Hillier's case along with Ms. Olguin. The state represented to the court that it would be a 3 or 4 day trial. Mr. Hillier repeatedly tried to tell the court that it would not. Mr. Hillier repeatedly asked for continuances based upon this vacation. Mr. Hillier put in a vacation letter and told the court that if it went longer than last week, then it would run into his vacation.
And a vacation letter does not a motion for continuance make. And this was the date that was chosen by the parties. This case had been reset before because counsel said he had a CLE to attend. So the court gave him time to attend his CLE, and this is the date that both parties chose.
And the court
And he's in the middle of a trial. And then we go back to the question is, if you're going to be his attorney, why were you not here during any parts of this trial? This is the first time that you've appeared to sit. And if Mr. Hillier knew he was not going to be here, why did he not have you qualified before the jury? It would have been a simple matter of his asking the jury, we're going to have Jason Goss who may come sit with us. Does anybody know Jason Goss?
Mr. Hillier believed based upon when the court set this case, if the court remembers, the court set it for last Monday. The court decided not to go to trial last Monday.
Because he said that he had a CLE to attend where he was seeking to obtain his board certification.
No, Your Honor, the week before. That was the week before. Last Monday was when this trial started. The court told the parties that they would start on Monday and be here Monday. The court decided not to start until Tuesday. Had the court started on Monday, Mr. Hillier would have been here today. I mean, the case would have been over on Friday.
Mr. Hillier had a choice to make. He chose to go on his vacation.
Your Honor, the reason that there are vacation letters is because the courts have recognized that it is not a choice when somebody has a family, when they have non-refundable tickets, when they have plans that have been made for over a year's time. In addition to, he is not in a position where he could join them late because they are on a ship in the middle of the ocean. So he is not in a position that he could leave his family.
So you're telling me that cruises do not dock in different places?
They perhaps dock in different places, but he could not make half of the vacation with his family and was not willing to have his family go along without him. And that is why there are vacation letters. So the defense is asking for a continuance to allow Mr. Hillier back.
Oh, that's going to be denied.
I understand. And additionally.
And have you filed a motion for continuance?
Defense is asking for a continuance from the court at this time based upon these circumstances.
So you have not filed a motion for continuance, is that correct?
We will file a motion for continuance.
No, my question is, have you filed a motion for continuance?
The motion for continuance was filed before and it was denied.
Have you filed a motion for continuance? We're in the middle of a trial. Have you filed a motion for continuance now?
We have not. We will.
That will be denied.
Yes, Your Honor.
All right. So the issue is whether or not state, do you object to this counsel being present?
Yes, Your Honor, the state objects.
And based, as I argued before, they do not have the right to have a question about whether somebody on the jury might recognize me or look at me and know who I am. That right does not supersede my client's right to counsel of his choice and to effective representation of counsel.
Well, the counsel he chose was obviously Mr. Hillier because he was here Ms. O'Gean was here. So those are the two counsels he chose from your firm. And again, we're back to the point. Why did you not appear for any stage of this trial before now?
Because the court and the state represented that the case would be done last week, and it was not. So based upon those representations made by the state, 3 or 4 days, which is on video and on the record, and the court, who believed that it would be done last week, I had other settings that I had to go and appear at. And so
Other settings that were jury trials?
other settings that were potential jury trials that didn't turn out to be jury
So
trials.
not jury trials.
Not jury trials, Your Honor. However, in this situation, the state objecting in this situation to me sitting and assisting Ms. Olguin is that right is so low on the totem pole compared to his right to allow me to sit here and assist Ms. Olguin.
So hypothetically, let's say somebody from the state's office were to come down to sit there and they haven't been qualified before the jury.
Right.
And you say, oh, that's fine. And then we discover, oh, their mom is on the jury. That
Right.
would be fine with you.
Well, I know my mother's not on this.
No, that's I'm giving you a hypothetical.
State does not have a constitutional right to
I'm
counsel.
giving you a
State
hypothetical.
does not have a Sixth Amendment right to
So
counsel.
let me ask you this. So let's assume your mom is on this jury. Do you think that you should still be allowed to sit? Let's assume one of your best friends is on the jury. Do you think that would be a fair trial for the state for you to sit?
I think.
Yes
that-
or no?
I think that their issue with that would not outweigh his Sixth Amendment right. It's a
Okay.
constitutional right versus the state's disagreement or some possibility that does not exist.
Mhm.
So no, my mother and my best friend are not on this jury.
Well, you wouldn't know that.
Well, so I would definitely know if my mother was,
Mhm.
right? So, and she's not, because I know where she is and she's not serving on this jury. As far as the other balance, it's just a balance of rights. I mean, I am here, I am willing to assist Ms. Olguin. It is important for my client's rights and the Sixth Amendment right to allow me to do that.
All right, are the jurors present? All right, let's line them up. All right, ladies and gentlemen, I have a few questions to ask of you. Mr. Hilliard is not present. As you can see, he's not present in the courtroom. The person who's now at this table is an attorney by the name of Jason Goss. Please stand. You may be seated. Does anyone recognize or know the attorney Jason Goss? If you do, please raise your hand. All right, so that the record is clear, no one has raised their hand. State, do you have any questions with regards to that matter?
I know, Your Honor.
All right, thank you. All right, with that being done, can I have attorney's approach?
Yeah, I'm going to go ahead and interrupt it there. This was a hearing that happened on August 4th. This attorney here is just a little bit back and forth with Judge Boyd. You can just tell that they love playing chess with the procedure, and that's entertaining to me. I like that. I like that more than hearing a pro se get up there and just sound silly. I think it's better to watch lawyers and judges, work the procedure and work the system that we consider the best. I think our system needs plenty of help, but this is certain. Certainly a challenge one. This video comes from KSAT. KSAT is the local news station there in San Antonio. If I don't get a video from the judge's stream, I always want to give credit to where the video come from. In the end, they're in a business, they're trying to make some money. Make sure to go and check them out. They put it up as a community service. I'm sure they don't mind, and if they do, I'm sure they'll let me know. But I just want to make sure everybody knew where the video come from. Here we're going to go to Judge Boyd, the recusal hearing. Now, whenever we watched the news clip the other day, it was brought up that Judge Boyd walked in. I thought that was really odd. But then whenever I started watching this hearing, it looks like they're in Judge Boyd's courtroom. And so it would make sense that she would go into her own courtroom to go to see somebody. It was still probably out of the scope of what she needed to be doing. But I'm going to always take Judge Boyd's Judge Boyd's side until someone can prove me wrong. So let's go look at that.
437th, Judge Bettis's court, and I don't know how that occurred because the motion arises out of the 187th and the hearing is always heard in the 187th, and so I don't know where the 437th came from. Also, there was some comment that it was canceled, and in tracing it back, it appears that somebody called Judge Boyd's court and asked the question if this hearing was going, and somebody told them it was canceled, referring to her afternoon docket, not this hearing. So once again, I apologize for the confusion, but we're ready to go now. Good afternoon. My name is Sid Harrell. I'm the regional presiding judge for the 4th Administrative District, which is headquartered here in Bexar County.
Okay, so moments, I get what you're saying. I get what you're saying. It's that they all look the same. But if you look at that nameplate right there, that nameplate says Judge Stephanie Boyd. I just can't believe that they would pull that nameplate and stick it in another courtroom. So I'm fairly certain that this is her courtroom. Or if not, I don't know why in the world they've got her nameplate there. So we'll go and see what we got.
Goes down to Webb County and over to the Coastal Bend, 22 counties. But today I'm here in the capacity of the presiding judge on a motion filed in cause number DC 2023 CR 11510A and DC 2023 CR 11510B and DC 2023 CR 11510C. And we're here on a motion to recuse filed jointly in those causes by the defense counsel on behalf of their clients. When received, Judge Boyd reviewed it, declined to voluntarily recuse, and under the statute referred it to me. And although there was a trial date set and I attempted to find somebody to hear the motion before that trial date, I could not find anybody, so I assigned myself, and this was the earliest date I could set it for a hearing. So let me do this. Let me have the parties' attorneys identify for the record who you are and who you represent, please. Don't everybody jump up at once.
Sure. Tom Nisbet and David Christian on behalf of Alfred Flores.
Eagle the Hood, Jay Norton, Patrick Valentine on Mr. Vila. What do we have, Judge?
Ben M. Cifuentes Jr. and Mario Del Prado for Elias Saad Alejandro.
All right. And we have representatives of the state here. They're not necessarily involved in the case, but we have Mr. Muller and Mr. Lunan here representing the state, but I assume you are the prosecutors on the underlying cases. Is that right?
Yes, Your Honor. Jeff Muller and David Lunan.
Okay.
Correct.
Okay, well, your motion, I've reviewed it, and some of these motions are denied without a hearing, but based upon the allegations in this one, I did set it for a hearing. But let me emphasize on these recusals, I know you're familiar with them. Statutorily, there's not a lot of law on recusals because the appellate vehicle typically is not there to appeal a denial or, for that matter, a granting. So you don't have a lot of law on these matters, but I will tell you the law that exists is rulings by themselves cannot be the subject of a recusal because the appellate courts have taken the position that rulings, even if they're wrong, have a adequate remedy at law on appeal. So rulings by themselves is not a vehicle. The mere fact that there's a proceeding in another administrative body has also been litigated, and that is not by itself sufficient for a recusal simply because that would result in forum shopping if that was the case. So I'm happy to hear those arguments, but you're going to have to combine those arguments with other things to justify a recusal in these matters. So you may proceed.
Thank you, Judge. Patrick Valentine, on behalf of Nathaniel Villalobos, but speaking for all the defendants in this case on this motion. Your Honor, the plan is I'm going to run through a PowerPoint presentation that contains some video evidence, and by the time I'm done with that, I hope that you'll understand what we're asking for, why we're asking for it, and most of the facts that support that. In addition, Your Honor, We would also call a few witnesses, those being Mr. Jason Goss, Mr. Tom Nisbet, and we have just served Jeff Molnar with a subpoena, and we intend to call him last, and possibly another witness, but we will see how it goes from there. So, Your Honor.
Let me just say this. I have a previously set Zoom hearing at 4 o'clock. So if we're not done by 4, I guess we'll have to resume in the morning, but I'm not sure about what her docket is. But let's see if we can get done by about 3:30 so I can make that Zoom hearing 3:45.
I expect we will. So, Your Honor, just to give you an idea of what these trials are and what these defendants are facing, these are Albert Flores, Nathaniel Villalobos, and Eleazar Alejandro. Mr. Flores and Mr. Elizondo are both charged with murder and other offenses, which you can see on the screen. Mr. Villalobos is charged with aggravated assault by a public servant and deadly conduct. All of these charges arise from the same incident involving the shooting and the death of a lady named Melissa Perez. They are in the 187th, of course, and we have moved for recusal of the trial judge, Stephanie Boyd. Your Honor, I know you're familiar with the standards that apply to these recusals, but it's always helpful for me in presenting these cases to just put them out there. So this, of course, comes from Rule of Civil Procedure 18B, and that states that a judge must recuse in any proceeding in which the judge's impartiality might be reasonably questioned, or the judge has a personal bias or prejudice concerning the subject matter of a party. Those are the standards under which we were operating today. Of course, we're not seeking a ruling on disqualification. We don't think that's there. These are the two criteria that we believe will be met by the evidence to be presented to you today. First, Your Honor, a little bit about those standards, and Your Honor's right, there's not just a whole lot of case law on interpreting this rule or how these recusals work, but there is some. One case from the Court of Criminal Appeals back in 2012 states that a trial judge must be recused if a reasonable person knowing all the circumstances involved would harbor doubts as to the impartiality of the trial judge. So what this means, judges, we do not have to show you that Judge Boyd is impartial. We don't have to show you that she is actually impartial or actually biased. It's an objective standard that says if a reasonable person, understanding the circumstances, would harbor doubts, meaning would have questions about the impartiality of the judge, that's enough to mandate the recusal of the trial court judge. On the matter of bias, case law also says that actual bias is not required to be shown. Parties do not have to prove what is going through a trial judge's mind. Of course, that would be impossible outside some sort of direct evidence. We don't have to prove actual bias here. And finally, Your Honor, on the matter of case law, our own San Antonio Court of Appeals has stated that bias usually stems from some extrajudicial source, such as an antagonistic relationship apart from the case itself. And we intend to show you that there is an extrajudicial source for the questionable impartiality and apparent bias of Judge Boyd in this case. So here are our grounds for recusal. There is a pending judicial complaint filed by Jason Goss against Judge Boyd. There are previous involuntary recusals, which Your Honor was a part of. And Judge Boyd's conduct during this case, and those being the denial of statutorily mandated continuances, insisting on using her YouTube-equipped courtroom, and pressing trial before discovery is complete. We believe those are evidence, not grounds per se, but evidence supporting the doubt as to her impartiality. So moving on to that first one, the pending judicial complaint. So September 20th, 2023, Jason Goss files
Let me say this just for the record. I served as chair of the Judicial Conduct Commission for 6 years, was on that commission for 8 years. They are very, very, very concerned about confidentiality of complaints. However, and I will tell you that the commission goes to great lengths to protect that confidentiality, and if you called up there today, they would not acknowledge anything about there being something pending because it is confidential by law. However, the exception is if the individual filing the complaint wishes to make it public or discuss it, then the commission nor I have any control over that. And the confidentiality kind of goes out the window. So, Mr. Goss, is that your intent?
Yes, Your Honor, for the purposes of this hearing, because I believe it's necessary.
All right, very good. You may proceed.
So Mr. Goss files a complaint with the Commission on Judicial Conduct September 20th, 2023. In that, he alleged that Judge Boyd violated the canons of judicial conduct by first maintaining a daily YouTube show from her courtroom, permitting commentators to demean defendants and attorneys while she watched, and conducting performative interrogations of defendants and attorneys concerning dismissals and plea bargain agreements, and also exhibiting bias and partiality by improperly inserting herself into a plea bargain negotiation in a particular case. Now, what's important about this complaint as it relates to this hearing is that it was found to be colorable and it remains under investigation. So, Judge, if I agree with the concerns expressed by yourself earlier, where a lawyer couldn't just file a complaint against a judge and then get all his cases moved out of some particular court, because that's just not a workable system, and it would lead to the perverse incentive of filing frivolous complaints for forum shopping. That is not what's going on here, Judge. This complaint was found to be colorable. It is therefore not frivolous, and it remains under investigation, meaning that Judge Boyd's disciplinary future is in doubt because of something that Mr. Goss has done and something that remains pending and not decided yet. That's what distinguishes this situation from any given case where a defense attorney might just file a complaint or might have filed a complaint in the distant past against some judicial officer. Also, we believe a source of Judge Boyd's partiality to be stemming from previous recusal. So late in 2003, I know Your Honor is familiar with this situation. She was ordered recused from 3 cases involving Mr. Goss and his law firm. The basis for these recusals were the pending Commission on Judicial Conduct complaint, but also the use of YouTube to broadcast courtroom proceedings and receiving live commentary during the broadcast of those proceedings.
Well, I'm going to correct you on that.
Yes, sir.
That was the allegation. The recusal was based upon the very specific facts of the case that underlie that, and it dealt with documented proof that comments, chats, whatever you want to call them, were being reviewed during the course of the plea, or the sentencing, or whatever that was. I don't recall, but it was very specific because I didn't want multiple just allegations. I don't want to be there because she's using YouTube. It was very specific to the very facts of that case when I did the order. So again, these were the allegations. I agree, but ultimately the basis for the recusal was very specific.
Thank you for correcting me. So, Judge, we believe at this point, under those circumstances, and there's more to come, but under those circumstances, Judge Boyd's impartiality might be reasonably questioned. A reasonable person, knowing that an attorney has filed a grievance that has found to be colorable and is again under investigation and pending, a reasonable person might harbor doubts as to that judge's ability to be impartial with regards to that attorney and his clients. So we believe that the analysis could stop right there. But we have more evidence to present after this. But one thing I do want to address is that there might be a question in Your Honor's mind. Well, that's fine for Mr. Goss and his client, but what about these other 2 gentlemen? How are they related to it? Well, in this case, the defendants have entered into a joint defense agreement. 3 co-defendants entered into this agreement to share resources, to distribute expenses, to allocate legal work, and to formulate a joint defense at trial. Our fates have been tied, their fates have been tied together since the very beginning of this case. Notice of that joint defense agreement has been given to both the state and the court. The trials of the co-defendants have been joined. They want them to be joined for the advantages previously stated, and there is no objection presently lodged by the state. And the state did take issue with the severing the trials initially, but once the co-defendants affirmatively waived their right to object on confrontation grounds with regards to the statements of other co-defendants, the state's concerns were resolved and they withdrew their motion to sever. So I'd like to talk about Judge Boyd's conduct in this case. Again, not because her rulings provide in and of themselves grounds for recusal, but because they support the inference of impartiality that I just talked about. So her conduct would include the denial of statutory motions for continuance, I'll get into that, insistence on using her courtroom despite its unworkable size limitation, pressing trial before discovery is complete. And I'm going to go over each of those in turn, starting with the denial of motions for continuance. So each of the defendants, and these are in the appendix, these motions are in the appendix provided to the court, filed statutory motions for continuance. These aren't just, we went to the bench and asked for a reset kind of Bexar County continuances, Judge. These were done properly pursuant to Code of Criminal Procedure 2906. And those were based on the unavailability of material expert witnesses, discovery not being completed, and finally, Mr. Goss's FMLA leave, which I will talk about a little ways down the road. So what's important about this is that each of these motions complied with 2906 of the Code of Criminal Procedure, meaning a court has very little, and really not much at all, discretion to deny a first motion continuance when it is properly filed, the matters required by that statute. And in fact, the statute itself actually says that if that motion be overruled and if the defendant is convicted, a new trial should be granted. Now, there's a recent case from Bexar County, arising out of Bexar County and from the Fourth Court of Appeals, where that court reversed a conviction where the trial court denied a continuance based on the expert's unavailability. So this is not some archaic, obscure statute. This is a real deal, live and active statute, and when the terms are complied with, a continuance is mandatory, and should it be denied, a new trial should be granted per the article itself. Now, when that matter was raised to Judge Boyd, that the statute itself says that you must grant this, and the matter of this potentially injecting reversible error was raised to the court, here's how she responded.
Congratulations, Mr. Goss, by the way.
Thank you.
If you want to read it, it's okay with me. It's in your brief.
Try it, Patrick.
Is there anything needs to be done up here?
Yes, sir. I've got it all the way up. Oh, I think you have the microphone all the way up.
You know, I'm very technologically illiterate, but if there's something that needs to be done up here, you're welcome to approach and see if something needs to be done on her computer.
There's a menu here on the speaker control, Judge, and I've got it turned all the way up, and it's not affecting the courtroom speaker audio, so I'm not really sure.
Let me show you a volume thing up here. Is this right here? I mean, this appears to be adjustable right here. Right, see how?
I do. I think that is to zoom the image.
Okay.
See if that does a good example.
All right, so here's the thing. When people want to throw out terms like reversible error, those already are like buzzwords. Judge, you're setting yourself up for reversible error. But here's the thing I want all the parties to understand about my rulings. I listen to what parties have to say. I make my rulings based upon the law. And whatever is within my discretion is within my discretion. I don't make my rulings based upon if this were to go up on appeal, what would the fourth court do? What would the Texas Supreme Court do? That is not in my purview. And so when people throw out terms like it's reversible error or if it's harmful, thank you for throwing that out. That's what I will say.
Okay, so Judge, the reason I wanted to play this clip for you is because it demonstrates that Judge Boyd has a bias against the law in this case and against a trial court's fundamental duty to avoid the interjection of error into its trial proceedings. It also shows a willful disregard of the function of the appellate courts in reviewing trial courts. I mean, I've never heard a jurist actually refer to the term reversible error as a buzzword. It is, of course, not a buzzword. It's a legal term. I mean, Your Honor's been a jurist longer than I've been a lawyer, but in 20 years, I've never seen a judge just openly express such contempt for the concept of avoiding error in our court and being reviewed on appeal. And so we think that is a piece of evidence which supports the reasonable inference from the objective standard that a reasonable person would harbor doubts as to Judge Boyd's impartiality in this case. Okay, Judge, there's also the matter of Mr. Goss being on FMLA leave. Mr. Goss is presently exercising his rights to leave under the Family Medical Leave Act following the recent birth of his daughter. This fact was brought to the trial court's attention. Mr. Goss had a vacation letter on file months in advance anticipating the birth for months now. But Judge Boyd would not consider that as a matter for continuing the case to some time when Mr. Goss could attend his family duties and then attend his duties to his client. We believe that is evidence of a particular bias towards Mr. Goss. When presented with this fact, Judge Boyd saw this as an opportunity to force Defendant Villalobos to sever out, to choose between his counsel of choice and the joint defense strategy that he had in place for over 9 months.
File is expected to be delivered today. And as such, as he has declared prior to this and for some months now, he will be engaging his family medical evac rights and taking time off to both care for his auto-age child and assist his wife in the care of their newborn child. So congratulations to them, but Your Honor, that would make Mr. Goss unavailable during the presently scheduled trial date. And before Your Honor rightly asked me, do you have other counsel in your firm? We do, of course. But Mr. Goss is our trial specialist. I'm no trial attorney. I do all the motions work, I do all the research, I do the appeals and things like that. But Mr. Goss is actually the person we want standing before a jury. He's the person that Mr. Villalobos wants standing before a jury and making those arguments and making the cross-examinations during the trial. Because he will not be available, we're positing that as another reason to court why a continuance of this trial should be granted.
And of course, then the granting of severance or not is also within the court's discretion. So maybe if you can't be here, then maybe you should be severed out from trying the case with the co-defendants.
So Judge, there's Judge Boyd saying you can either have your trial lawyer or you can have your joint defense strategy, but you can't have both. Now, why is that? Like, is there something imperative about the timing of this case? Because that would be a justification potentially for trial court denying a continuance, at least based on the FMLA grounds. But there's really not. The date of the alleged offense was June 23rd, 2023, a little more than a year ago. The date of the indictment wasn't until December 14th of last year. So that means we're not even a year into the indictment of this case. But George Boyd, importantly, she has stated that there's no imperatives justifying the fast tracking of this case. She has not provided any reason for that. And we would submit to the court that her reason is that, well, she just doesn't like Mr. Goss, and she just wants to, and by extension his firm, and by extension his clients, and by further extension the co-defendants in this case. And she wants to press the trial with no real reason why we should be going to trial that quickly. Now that in itself, again, Judge, not a reason for recusal, but it does support the inference of a lack of impartiality. There's also the matter of refusal to consider appropriate court space. So very early on in these proceedings, Mr. Nisbet raised to Judge Boyd the concern that, well, trying 3 defendants together in this courtroom is really not physically workable. That's the table we would all be sitting at. So even if you allowed 1 lawyer and 1 defendant at that table, that's 6 grown men sitting around this table. And I'll let you hear what Judge Boyd, or how she responded to his concerns.
Yeah, I'm here, sir.
Y'all want a jury trial?
We do, Judge.
All right, Ms. Ferguson, I need a jury trial. Dave, how long is this trial gonna last?
Logistically, I could say in upwards of 3 weeks. Judge.
No. How many witnesses y'all have?
State anticipates, on my initial witnesses, approximately 25 right now.
All right, so some of those witnesses, I don't think they're probably gonna be 25.
Judge, next, speak on it a little bit. There's a joint defense agreement in this case. So when I say logistics, I'm referring to not only space, but also time. We're gonna have to accomplish a counsel table or an area that can accommodate 3 lawyer teams and their respective clients.
All right, so when y'all say 3 lawyer teams, I can tell y'all the space, turn around, the space that you see in this courtroom is the space that you will have. So if lawyer teams want to bring paralegals and everybody else, they're going to be sitting somewhere in the gallery.
Well, let's just assume for a moment that there's 1 lawyer with each client. We know there could be more. I don't know how you set 6 grown men at that 1 little table.
Y'all gonna have to squeeze in. I understand. You guys will have to squeeze in. Guess what? This is what the county has available. This is what the county is paid for.
Which is why we're bringing it up. We're curious what else the county has available. Other courtrooms that are larger entities. Well, I think there's other ones, and so we'd like to explore those possibilities. We wouldn't want to deprive clients of the presentation of the evidence at all. So we're putting it before the court early, in earnest, wanting to be candid with the tribunal, and then hopefully find.
I appreciate that, but what I will tell you all is judges rarely, if ever, agree to switch courts. So this is where we are. Yes.
I did not mean to interrupt. Do have an issue.
So Judge, when we asked for, at least to just explore the accommodations of a courtroom that would be able to accommodate all of the defense counsel and staff involved in this case, well, Judge Boyd refused to even consider that. Now, it'd be one thing if she reached out and said there's just nothing available. But you heard she made the decision right there without picking up the phone, without calling any other judge, including herself, to see if anybody could arrange a courtroom that would be appropriate for this kind of case. And why would that be? Well, one inference to be drawn is that she's displaying a lack of impartiality towards Mr. Goss and by his extension these other defendants. Another is the way she has her courtroom set up, Judge, because I need to talk about this for a little bit. Sorry about that. As Your Honor knows, she runs a YouTube channel out of her courtroom on a daily basis. That receives thousands of views daily. Trials receive tens of thousands of views. Those videos remain posted and archived on Judge Boyd's YouTube channel, despite the fact that some resulted in acquittals and expunctions. That's another issue. And what's more, these videos, we believe she is using as a manner of self-promotion because other people take these videos, they chop them up, they put them into TikToks, they put them in Instagram shorts, and they put them into other YouTube videos, and they are put out there for the aggrandizement of Judge Boyd and the demeaning of defendants and counsel in her court. These are just a couple of the thumbnails from videos on there. And the theme of all the videos, and there are hundreds if not thousands of these at this point, is Judge Boyd has no patience for this defendant. Judge Boyd's not taking this defense attorney's crap. In the top left-hand corner, that's actually an attorney in our firm. That video has had over 20,000 views. And that's an example of what she is doing and what she is being allowed to do. And I would submit that that's beneath the dignity of the court. Here's another channel. It's actually called Judge Boyd TV. This is one of about a half dozen channels that I could find that regularly mines Judge Boyd's video feeds for content and then puts them out there in a manner that demeans lawyers and defendants in her court. One thing particular to this case is this one, because you'll see, it's a little hard to see, but that guy right there, that's Mr. Goss. So Judge Boyd rips defense attorney apart for prioritizing vacation over trial. That video has had over 25,000 views. I'd like to, just to give
you all guys a heads up, that's one of the reasons why my thumbnails are what they are. I don't want any thumbnails or any videos that I do to ever be used against a judge. That's just not good business. But the one channel that was called Judge Boyd Live or Judge Boyd something, there's even a YouTube channel called Judge Boyd. Both of those is completely against YouTube's terms of service, and if YouTube gave a damn, they would shut those channels off. You're not allowed to do a channel where you use the person's name. You can do a channel to where you say Judge Boyd Tribute or Judge Boyd Fan Club, but you can't do a channel that's called the name of that, like Judge Boyd Live. You can't do that because that's insinuating that you are that person. And so you just always got to be careful on that. Absolutely, moments you're saying Judge Boyd, it doesn't mean it's hers, but using that name like that is against YouTube's terms of service. So just pay attention to the channels you guys watch, pay attention to the videos y'all watch. But either way, yeah, moments you put both have been reported. I don't know if they've been reported. I've never reported a channel, so I don't know how that works. But yes, court vibes. Yes, you can do, Kathy. You can do a channel called Bill. Absolutely, anytime you want to. But anyways, yeah, and then some of them are clickbait. Yeah, there's some of those channels that are just, they're just asses. There's no, it irritates me that I even click on it to waste that time, but we're going to get back to it. But some of these ones on here, I'm truly glad that one of my thumbnails wasn't used. I'm truly glad that, I would hate to know that I was used against a judge. In the end, I want to show the court and have an entertaining time, but then move on. But I don't, you know, the judge or the attorneys, you know, in the end, I want justice to win. I want the, you know, right and wrong. You know, we see the prosecutors and defense attorneys. I don't know how someone can be a defense attorney. I just surely don't. But either way, let's jump back in.
An idea of what we're dealing with, and this will be the last I say on this matter, but here's an example, a video example of an actual hearing in this case that has been recut and redistributed and amplified due to Judge Boyd's insistence on conducting her daily YouTube show.
All right. Is there anything else from either side? Any more arguments? All right, defense, your motion for continuances are denied. All right, defense, your motion for continuances are denied. All right, defense, your motion for continuances are denied. We're doing jury selection on the 20th. I am aware, and I heard your argument, and I internalized your arguments with regards to your experts needing to hear testimony as they're excluded from the rule. As you all know, the court live streams, so they will be able to watch all of the testimony because it will be live streamed and they can watch that at their leisure.
So that's the world we're living in here, Judge. And I want to be clear, Judge Boyd is not producing any of this content, but she is producing the content which allows these creators to amplify these and make a circus of the trials and the proceedings in her court. So the last note I have on the matter of the YouTube broadcasting is that this is Rule 18C is from the Rules of Civil Procedure. This only applies to civil cases, Judge. Now, I'm not going to say this applies to a criminal proceeding because it doesn't. But what it shows is that there's a concern for the dignity of the courts, the anonymity of witnesses and parties to litigation sometimes. And so it places restrictions on when a court can actually record or broadcast proceedings. Now, there's no such analog presently in the criminal system, but I would submit to the court that this rule informs the gravity of the concern that we're bringing to the court today. Your Honor, discovery in this case is also incomplete.
Actually, in a civil case, parties can object.
Yes.
And the objection has to be granted. Okay, I interjected that. But yes, in a civil case, there's a definite statute allowing parties to object to videotaping or streaming, anything of that nature.
Yes, and I'm hopeful the Court of Criminal Appeals will come to some sort of, bring us some sort of guidance on this issue, but we're just not there.
I think the Supreme Court is actually looking at guidance in regard to this matter as we speak, but it hadn't come out yet.
Understood. So, Your Honor, also, as I mentioned earlier, discovery is incomplete in this case, which is another reason why no reasonable jurist would put the parties or the state to trial in this case at this time. So, in August, Mr. Mulliner was assigned as the new lead counsel in this case for the state. Mr. Mulliner also filed a motion for continuance seeking additional time to review and prepare these cases. And since he has come on the case, additional discovery, including Brady evidence, has been produced and disclosed to the defense. That's of special concern, Your Honor, because under prior leadership, the Civil Rights Division frankly habitually failed to disclose Brady evidence, leading to multiple mistrials, 2 of which our firm was involved in. And in each of those cases, the state ended up dismissing those cases before the double jeopardy writ hearings could be conducted. So we never got to put anybody on the stand, but the state dismissed the cases. And I bring that up not because it has any direct relevance to this proceeding or these trials, but because it highlights the importance that Mr. Mulliner and Mr. Lunan, the importance of them being able to have the time to look through the evidence, to go over to SAPD, to talk to witnesses, and determine whether there's anything else they need to disclose pursuant to their statutory and ethical duties under 3914 and Brady and Rule 309.
And Heath versus State, which just came out.
It did, Your Honor. I'm not optimistic we could get sanctions in this case, though. Yeah, rehearing was denied. Is that the last word?
I believe so.
Okay.
But I mean, in other words, what I'm pointing out is it puts an absolute duty on the state to inquire and determine if law enforcement agencies have Brady material And I guess we have to assume that the law would necessitate a continuance for them to have time to do that to protect themselves, because we now have DAs being sanctioned for not complying with Brady and its progeny and the Morton Act. So, anyway, aside.
Yeah, and my position has always been that the state cannot ethically announce ready for trial until they're certain that they've disclosed and made their diligent investigation of everything they need to disclose in the case. But this matter was brought to Judge Boyd's attention. That discovery was ongoing and discovery was still being produced, and that the state needed additional time to review their files and talk to law enforcement. Judge Boyd took the position that the defense attorneys had signed a discovery acknowledgement months ago, and that discovery acknowledgement, she believed, indicated that discovery was complete in the case, the discovery was closed. Well, I don't need to tell Your Honor that's not what a discovery acknowledgement is. A discovery acknowledgement is, of course, a record of what has been produced so far. It is not an acknowledgement by the parties, of either party, that the discovery process is complete. But when this was brought to the judge's attention, here was her reaction.
All right, so here's the problem that y'all can remain seated. This is the problem that I don't think anyone is getting here. We have been on discovery for over a year. Everybody signed an acknowledgement of discovery saying they had received everything. So the court is going on the basis that you all have received everything. That's what everybody signed.
So she's proceeding on the basis that everybody has received everything because the discovery acknowledgement was signed. But as again, that is not what a discovery acknowledgement is. Your Honor, we would posit that as another reasonable inference of her lack of impartiality in this case. So wrapping up my PowerPoint, recusal of Judge Boyd is mandatory under these circumstances because her impartiality might be reasonably questioned in these cases. That is the standard under Rule 18b(b)(1). Moreover, she has indicated a personal bias or prejudice towards Mr. Goss and by extension everybody else involved in these cases concerning the subject matter or a party. That's under Rule 18b(b)(2). So to frame it another way, according to how case law says, Judge Boyd must be recused because a reasonable person, knowing all these circumstances we've just related, would harbor doubts as to her impartiality and bias. Again, we don't need to show actual impartiality, we don't need to show actual bias, but we have shown plenty of doubt as to her impartiality and bias in these cases, and that meets the standard for mandatory recusal. And with that, Your Honor, I conclude my PowerPoint presentation. And if you would like to hear from Mr. Goss, we can call him. If you think you've heard it enough, then I'll go with however you want to play it. Okay, well, we'll call Mr. Goss.
All right, I'm inclined to waive the oath as he's an officer of the court. If nobody has any objection, you can have a seat in the witness stand. Okay, briefly, you may proceed.
Yes.
Your name is Jason Goss, right?
Yes.
Spelled G-O-S-S?
Yes.
Okay, you're an attorney representing one of the co-defendants, that being Nathaniel Villalobos in this case?
Yes.
Okay. Mr. Goss, I'm gonna kind of run quickly through this. I'm gonna ask you, first of all, I want to start with a trial proceeding that happened a little before this. You were involved in the trial of a defendant charged with manslaughter, correct?
Yes.
Was that in front of Judge Boyd in the 187th District Court?
Yes.
Can you tell us what about that trial informs the court's decision in this motion?
So, for one, when we had the previous recusal motion, we did not, as the judge pointed out, we did not file a recusal on this manslaughter case that we had just recently tried, because we didn't have some of those things that we have in this case and some of the other cases with the YouTube comments and everything else. But during that trial, one of the things that frequently occurred that concerned me was I was trying the case with Jasmine Olguin, who is an associate in our firm. She has been licensed in November, she'll be licensed for 2 years. And while I was sitting with Ms. Olguin on that case, I was told several times by Judge Boyd in front of the jury that I was not allowed to speak, that Jasmine was my lead counsel, and that I could not make arguments on the issue that we were trying to argue. Of course, I objected, and at the time the case worked out for us, but I had issue with that, and then I had to basically transmit arguments and things on some of those issues through counsel, through Jasmine, which told me, just based by her conduct in that case, that she was not treating me as she would treat other lawyers who are senior lawyers who are sitting on the case and should be allowed to make arguments on behalf of their clients. And that occurred last month. So that case was what was happening last month.
If you look on the screen, I have a slide I displayed earlier. Is that slide and the video clip that accompanies it, is that from the case you're talking about?
Yes. Yes, I had to. I had to come in as counsel because one of our other counsels who had informed the court that he was on a non-refundable vacation, the court started the trial anyway, knowing that it would not be done a week, and we were told, she was told it would not be done a week. She made our associate and Jasmine go to trial. Subsequently, when the case did go longer than a week and he had to go on the vacation because it had been planned for over a year, then and it was non-refundable, I came in. I had to come in because there would only be left with Jasmine, who had not tried a manslaughter, who was not. She is a very capable lawyer, but she is a very capable lawyer and a great lawyer at the beginning of her career. So in that clip, Judge Boyd grills me for about 9 minutes, ultimately bringing the jury in, asking them if they recognize me, and then allowing me to sit. Only after I went through this this performative, I think, questioning, and honestly with the intent to disparage or humiliate me, she finally allowed that after going through all of that.
And I want to ask you about the grievance that you filed. Can you tell the court what you know about the status of that grievance at this point?
So I've been contacted by the Judicial Conduct Commission. They've asked me for evidence. They've asked me for everything that I have, which I have provided. A lot of the screenshots of the comments that the trial court was allowing back at the time, and the disparaging comments towards members of the legal community generally, but specifically to us. Xenophobic comments that one of our counsel who was born in England or in Great Britain should go back to his own country, and all of these things were on her own website or on her own YouTube channel. And so I provided all of that to the Judicial Conduct Commission, and my understanding is that they have it and they are continuing to investigate. And I have just told them I'm available for any other issues that they may need.
And did any organizations make any efforts in support of your complaint?
Yes, I was asked by SAGDALA to present my complaint to the executive board of SAGDALA, who all agreed and then filed their own amicus brief, basically, as well as their own judicial conduct complaint, citing the things that I cited and a few additional things, where they mainly focused on the fact that she was leaving up trials of defendants who had been acquitted and therefore expunged, which would violate the statute against publishing expunged cases, and really subjecting those defendants who had been acquitted to further ridicule for terrible offenses that they've been charged with.
And just for the record, SACLA is the San Antonio Criminal Defense Lawyers Association?
Yes.
I want to ask you about the previous recusals. Judge Harrell is very familiar with that, so we need to go into the substance of them. But since those recusals have been granted, when you have had occasion to go into the 187th District Court, or when the other counsel in your firm have gone in, has there been any change in her behavior?
Yes.
Can you describe that?
She has, as I described with the trial that I had to come in on last month. I have never before been told that I cannot argue on behalf of my client, making valid legal arguments. and that I had to transmit my arguments through another person. And this would be arguments that weren't on a person's witness or something like that. Additionally, she has been cold. She has been insulting at some times. She has said, she has made hand gestures towards me when I'm speaking, like to make me be quiet. She did that in front of the jury. She has treated me as if she is angry or upset with me because of the basis of my grievance.
Well, let me ask you a question real quick.
Yes.
Have you had discussions with her about the grievance itself, or did you give her a copy of the grievance?
I didn't.
So she's never acknowledged to you herself that she's aware of the grievance is pending? To you personally?
She has not acknowledged to me personally she is aware that it is pending.
Has she acknowledged it to anybody that you're aware of?
I understand that the grievance committee contacted her to preserve, because I had asked to preserve the videos and the comments so that they would not be deleted once she was. And I understand that that has happened.
Okay, thank you.
And have attorneys in her court, attorneys from our firm who have appeared in her court been made to wait till the end of docket before they could be heard?
Yes.
And sometimes the entire morning?
Yes.
And sometimes recalled into the afternoon?
Into the afternoon, yes.
So, Mr. Goss, first of all, I've congratulated you, but on the record, congratulations on the birth of your daughter.
Thank you.
Okay. Prior to your daughter being born and subsequent to your daughter being born, have you sought continuances based on your Family Medical Leave Act leave and other courts?
Yes.
Have you ever had any court deny you a continuance on that basis?
No. And I've never heard of any court ever denying any attorney on that basis.
Now, Judge Boyd made the suggestion that, well, we could sever our client out and then you would be able to try the case when you return from your leave. Why is that not an acceptable solution?
Because the reason we have the joint defense agreement is because we all believe that it is in our client's individual best interest to have the case tried together, in particular because we each have individual experts for our clients, but we are each counting on the ability to use the other defendant's experts to support our case, as well as if they testify, they are going to testify as a joint front. And we believe that, especially with Nathaniel Villalobos, because of the particulars of that case, and as you can see, he's been charged with something different, we believe that it is important that Mr. Villalobos be tried together with everyone else so that all of their actions can be considered by the jury at the same time, by the same jury that all of us have picked. And we have met multiple hours. We have gone to the evidence room together as a group, meaning all three defense attorneys, or all three groups of defense attorneys. We have strategized. We have with each other for the last, since the case was indicted in December of 2023. And without, so it puts me in a position of having to advise my client, either you get me or you get your best defense. And it's an untenable position to put me in as an attorney, because I have to take care of my child and my wife and all of those things. And my client has to have the best defense that's available to him. And we have all determined that that is as the group, and that's why we have joined. And that's why we have a joint defense agreement.
And Mr. Goss, concerning the grievance, is the fact that you filed a grievance against Judge Boyd common knowledge in the criminal legal community of Bexar County at this point?
Yes, it's been reported in the news. The Sagdala grievance was, that part of the grievance, and the fact that it contained me has been reported in, I believe, San Antonio Express News and KSAT. I did not speak to any news organization about it, and I did not I did not make comment about it personally, but I know that Sagdala did.
And do you believe that Judge Boyd has exhibited a personal bias towards you in this case and in other proceedings since that grievance was filed?
Yes.
What's the remedy for violation of the Family Emergency Leave Act?
I'm not sure.
Just curious.
I don't know. I've never heard of anybody violating it.
I mean, I've seen the statute.
Yeah.
Judge, I apologize. Could you step out because I don't want them to try to call you.
Sure. Thank you, Judge.
All right. Okay, what else we got from Mr. Gospel?
Mr. Goss, you were a prosecutor for a defense attorney?
Yes.
How long were you a prosecutor?
For 9.5 years.
How long have you been a defense attorney? About 6 years, right?
January 2019.
Okay.
Yeah.
In all your years practicing, have you ever seen a judicial officer deny a properly framed and filed motion for continuance under 2906? That was not brought on the day of trial?
Yes, I have seen it. I have seen it one time, and it was reversed.
And has any other judge in Bexar County or the other counties you practice in denied continuances for you on that basis?
No.
Well, I don't know if I passed the witness or just...
I don't know. Y'all are entitled to ask a question if you want to. You don't have to. Okay, you can step down. Thank you.
We'll call Tom Nisbet. I'll be brief with him.
All right, same thing. Officer of the court, I'll waive the oath if you'll have a seat. Yes, Judge.
Tom, your name is Tom Nisbet, right?
Yes, sir. Nisbet.
And you represent Alfred Flores in this case, do you know?
I do, sir, along with Mr. David Christian.
Previous to your going into private practice, were you a prosecutor with Bexar County DA's office?
I was employed with the county from 2008 till 2022. I was a assistant district attorney here in Bexar County from late 2009 until January of 2022.
And what was your last assignment in the office?
My last assignment was I was the Criminal Trial Division first chair of the 187th District Court. This court, that chair that you're sitting in right there in front of Judge Boyd. From starting, I was asked to audit the court's docket in April of 2020 and officially moved into the court August of 2020 because of COVID through January 22nd of 2022.
And as in your capacity as first chair in the 187th District Court, you obviously had many occasions to view Judge Boyd's conduct and the way she handled various matters, including continuances, correct?
Yes, sir. On a daily basis. This was a court that stayed open during COVID. Interestingly enough, I was witness to the genesis and rise of the use of Zoom and subsequently YouTube in this courtroom with this particular judge. But to answer your question directly, hundreds of cases across weekly, monthly, yearly basis being handled of all different types in this court in front of Judge Boyd.
Have you Now let's take a serious case, a complicated case, a murder or something else that is more than your average felony case. Have you seen Judge Boyd deny a continuance on a case that's less than a year old and force the defendants and the state to trial, such as she's doing in this case?
No, and I spent some time looking back through names that I remembered off of the docket, and never a first trial setting. A first trial setting would never be denied a continuance, even if it was a sort of Bexar County special impromptu oral one at the bench, let alone 3 to 4 written, verified, detailed, perfected first motions for continuance under 2906. Never saw it.
So were you in the court when the YouTube thing started?
Yes.
Okay, can you talk about whether that you saw a change in Judge Boyd's judicial behavior upon that evidence?
I would say yes. The technology curve improved here in Bexar County as a whole, but this particular court used the picture-in-picture frame to show the judge, while it's also showing whichever litigant was speaking at the time, which is unique and different than other courts. And that the fact that you get gently reprimanded based on how you move around in the courtroom to try to keep you within the camera shot, which is in the well. If you turn your back to the camera, you're told that the court reporter can't hear you, but she can. Things like that.
Can you tell us about the scene that Judge Boyd sets every morning with regards to the camera that is facing her?
Sure, she goes through her comments, right? She sets up her handbag next to her flower display, and she goes through a series of, I'm going to call them ovations. Most have jest packed into them to get laughs, either online or in the courtroom, before she actually calls the docket and begins serious business.
And have you ever known Judge Boyd to have her rulings influenced based on who might be watching the YouTube videos?
Yes.
Can you talk about that, please?
There was a case that should have been a VTC acceptance.
And that's Veterans Treatment Court.
Yeah.
Correct.
The case actually belonged to Mr. Goss. The judge was going to, I think, grant a application for probation, and I'm going to say after something influenced her decision, she changed it and she sent him to TDC afterwards, I think for 4 years.
And do you have any knowledge of what it was that changed her decision?
I think it was a phone call to her mother. I'd like to speak to that a little bit.
Yes, sir.
It was known to me that part of the YouTube genesis in this courtroom was installing a big screen TV on the wall of the judge's mom's house back in Louisiana so she could watch her daughter in court every day, kind of like a TV show. And that it began to create content, and that the content obviously started to take off online. And so it was my impression that the TV show, as it were, and somebody watching at home influenced the outcome of that punishment trial that day.
And I think you said that was the case where Mr. Goss represented the defendant?
Yes.
Okay. In all of your experience, both as a prosecutor every day in this court and as a defense attorney who frequently appears in this court, have you ever seen Judge Boyd treat any other defense attorney the way that she has been treating Jason Goss for the last year?
My answer is no, and if I could expound on it.
Yes.
I think, and it's probably gone after this, but I had a lot of goodwill with the judge. When I was her prosecutor, I improved her docket numbers significantly and placed her into a high-ranking position against the other district courts. And I always enjoyed a professional, respectful treatment from her as a DA, as I did when I would come in here as a defense attorney, beginning in January of 2022. And I have never experienced anything remotely close to what's been going on in this case by another judge as a DA or a defense attorney, or certainly by this particular judge in this case.
So do you feel that the lack of impartiality or the personal bias that Judge Boyd directs at Mr. Goss has now extended to you and your clients?
Very much. I think the stain or the creep has made it into Mr. Cifuentes' client. It's made it into obviously Mr. Goss's client and very much for our client, Mr. Flores. And it's going to affect a very serious matter that's very important to the community for all members involved. And at least the appearance of the partiality and the bias is there, in my opinion.
As an officer of the court, bound to tell the truth here, I'm just going to ask you directly, do you believe that any of the defendants in these cases can receive a fair trial from an impartial jurist in front of Judge Boyd?
I do not.
Thank you all. Pass the witness if there's questions.
Step down, thank you.
Okay, Judge,
Still here?
Your Honor, we call Mr. Jeff Mulliner.
Mr. Muller, again, officer of the court, would you please come up and have a seat? I will waive the oath. Thank you.
Yes, sir.
Jeff, would you please state your name and spell your last name for the court?
Yes, it's Jeff Mulliner, M as in man, U-L-L-I-N-E-R.
Can you tell us how you're presently employed?
I'm an assistant criminal district attorney. Specifically, I'm assigned as the director of the Civil Rights Division for the Bexar County District Attorney's Office.
And are you at present the lead prosecutor on the cases before the court today?
I am.
I just want to go, for the record, go back through a little bit of your experience. How long have you been licensed?
About 31 years, roughly.
Okay. And correct me if I'm wrong, but in the initial part of your career, you were a prosecutor.
Correct, including an internship where I worked under a bar card. I was here for about 11 or so years at the DA's office.
And then you went into private practice.
For 20 years, almost exactly.
And focused primarily on criminal defense?
Exclusively.
Okay. And then when did you rejoin the district attorney's office?
January 6th of 2023.
And
no.
I'm sorry.
Yeah, that's right.
Okay. When were you assigned as lead prosecutor on this case?
I was notified, as was, I guess, the community, really with a press release that went out on July 31st of 2024. I was at that time, well, I've answered your question.
Okay. Now, since coming on to this, first of all, let me kind of ask you, would you describe this as a complex case?
Absolutely.
Okay. What do you think makes it complex?
I would say it's 3 complex cases that have been joined together, and what makes it complex is multiple factors, but the indictments in the case, I think it was one of the first slides you put up, there's multiple counts with multiple defendants, and so that is really something that requires some time and some care to review the indictments and make sure that they comport with the anticipated evidence, make sure that the wording is correct. The jury charges in these cases based on the indictments are going to be very complicated. Further, what makes this really a complicated case is the fact that anywhere across the country, charging somebody that was discharging duties as a peace officer at the point in time when they are then facing criminal charges for that conduct is exceedingly rare on a relative basis. Relative to caseloads across the country, charging somebody that was at the beginning of their shift on a day that they end up facing a charge, acting as a peace officer, it's a very rare thing, and there are unique defenses that are very complicated that relate to somebody that was working at the time of the alleged conduct as a peace officer. Peace officers have much more kind of complicated defenses that they can assert than a layperson. The fact that these cases are being brought together, which I was vehemently objecting to until such time as your clients all started giving very personalized waivers of their rights to confrontation. And so until that happened, I didn't envision that it was reasonable to proceed with a joint trial. But after that happened, then it really resolved a good number of the concerns that Mr. Lunan, Chief Lunan, and I would have as prosecutors. But that was only recently, so it's only been in the recent past that we've been analyzing this as a joint trial for 3 officers at the same time, where the charges include but are not limited to allegations of murder as presently exists in the indictments of Sergeant Flores and Eleazar Alejandro.
And you mentioned a Mr. Lunan. Would that be David Lunan?
That would be David Lunan.
And Mr. Lunan is presently chief of the trial division in the office?
He is the chief of the criminal trial division for the Bexar County District Attorney's Office.
And is he also a, let's say, recent addition to this case?
He is. A very short time prior to my entry into the case, I believe he had agreed that he would participate with the case. And so both of us together are quite new.
Would you describe the discovery in this case as voluminous?
I would.
And that's both in terms of documentary evidence and video evidence, correct?
Yes, sir.
Okay. In addition to that, there's just a whole bunch of witnesses, right?
There are a great number of witnesses. That's correct.
Most, if not all of whom, you need to interview before trial, right?
I wouldn't feel that I was acting with the appropriate due diligence unless I did a pretrial conference with anybody and everybody that could reasonably potentially be a witness in the case, or anybody that may have Brady information that I should know about.
I'm glad you mentioned Brady, because one of the things prosecutors do when they interview witnesses is not only go over what their testimony might potentially be, but also be on alert for those things which the prosecutor might have an obligation to disclose to the defense. Am I right in saying that?
You are correct.
Okay. Have you had the opportunity in the time you've had the case to sufficiently interview all the witnesses you would like to complete your ethical duties?
I have not.
Because just to make it clear, you didn't work up these cases, meaning you did not receive the investigation and complete it and present it to a grand jury, right?
Mr. Ballantyne, on August 6th of 2024, I did not know the names of any of the defendants in this case because it has not been my practice in recent years, for many years, to really pay attention to cases that I'm not directly involved with. I was directly involved with all of the death-related cases arising out of the 186th District Court, the Criminal Trial Division, and that was more than sufficient to occupy all of my available time and attention. And as I believe I indicated, there was a press release indicating that I had been appointed to serve in this new position that went out on July 31st. And I had ongoing, continuing obligations in the 186th, and it was the 7th of August of 2024 when for the first time I ever pulled the indictments and saw for the first time the names Flores, Alejandro Villalobos. I just knew that there was a case with 3 officers that had been charged just generically prior to that date.
And have you yourself, along with Mr. Lunan, do you feel you have been able to go through all of, not just to disclose what you needed to disclose, but actually to review yourself all the evidence that exists in this case?
No. And it is important on a number of levels that we have that opportunity. Some of them are for the sake of the community. Some of them are for the sake of the next of kin. Some of them are personal for the sake of Mr. Lunan's law license and mine, and not insignificant at all are for the sake of the accused Flores, Alejandro, and Villalobos. Everybody is requiring, deserving, and entitled to fairness and justice in this proceeding, and there has not been sufficient time for me to have any degree of faith that we are poised to make sure that that will happen.
So do you believe that you can proceed to trial at this time and still comply with your ethical duties? Well, let me put it this way. Are you uncertain of it?
I'm a gunner. I'm going to burn the candle at both ends. Mr. Lunan is a gunner. He's going to burn his candle at both ends. We have excellent people that are helping and trying to facilitate the work that we need to do. We are going to give an unbelievably dedicated, good old college try, but I'm concerned that it will fall as insufficient.
I appreciate that answer. Discovery is still ongoing in this case. Is that an accurate statement?
That's accurate.
And even very recently, you have disclosed to the defense information which you believe may constitute Brady evidence. Is that right?
Yes, what's potentially Brady to one what's potentially exculpatory to one may be potentially inculpatory to another, but these are 3 individual human beings that have been accused as a result of the separate indictments in this case, and Brady is at stake with the ongoing discovery that is happening. I can tell you that Chief Lunan and I and the other members of the team who are aiding and facilitating us in our efforts to get on top of this pile as quickly as possible, we determined thus far through the course of our investigation that it was highly likely that there was spent slugs that had been collected and not yet tested by the serology section of the medical examiner's office, or evaluated by the ballistics section at the crime lab. And we further formed what we believe rises to the level of probable cause to believe that there was a spent slug inside of a wall that has never been recovered, and at our direction and under our control. And just Friday, through a search warrant that we were directing to be acquired, a wall at the scene of the alleged offense was broken into, and they did in fact secure a spent slug. And I would pause for a moment to say that in this case, there is an allegation that reasonable minds might disagree, but generally I think that somebody that had looked at the evidence would believe that we're talking about a total of around 16 shots fired cumulative amongst the three individuals that are charged in this case. And so we have not been able to account for 16 spent slugs. So every additional spent slug that we can acquire is potentially significant, potentially exceedingly significant, because, and now this is a hypothetical, a spent slug that has not previously been examined or evaluated could have tool marks on it, whereas we would have access to an expert that would be able to tell us from their craft which one of the firearms it came from, and if there were biological material on that spent slug, that biological material could be further submitted for DNA testing. And so hypothetically, if a spent slug that has not previously been evaluated for either ballistics or serology that we have uncovered during our investigation, that we have caused to be submitted over to the crime lab, where testing is ongoing as of this moment, if one of them were to come back to a particular gun and have biological material tied to Melissa Pettis, that would be inculpatory as to the person from whose gun we would be suggesting it came from, and exculpatory as to the other two individuals charged. It's quite frankly maddening to consider the possibility of going to trial in such a rare, as I said before, cases against individuals that were acting as peace officers at the time that their conduct is alleged to have risen to the point that it has violated a criminal statute. It is very rare, and it's rare in this community, and it's rare in this nation, and peace officers are not entitled to extra justice, but they are certainly not to be denied full justice that would be constitutionally deserved and demanded by anybody and everybody. And the fact of the matter is proceeding to trial with evidence that could potentially be exceedingly significant that has not yet completed the evaluation lifespan to the point of conclusions is in fact maddening.
And did you bring to Judge Boyd's attention the fact that your investigation and discovery production was still ongoing as we approached trial?
I would say that the best evidence of what I brought to Judge Boyd's attention is the record from the initial motion for continuance and any statements that I or my co-counsel made at that time, plus the verified motion that we caused to be filed itself. I don't really recall, and much of this investigation that I've been talking about in my very most recent testimony had not yet occurred at that time. The reason it had not yet occurred is because Chief Lunan and I were still in the early stages of our evaluation of this case, and we had not yet got to the point where we realized we have potentially access to potentially exceedingly significant evidence that has not been evaluated and needs to be for the sake of everybody.
And the verified motion you referred to, that was you and Mr. Lunan yourselves filed a motion seeking a continuance at the request of the state. Is that right?
Correct.
Okay. And that was a verified motion?
Correct.
And did that motion, while maybe not all the particulars, did it express the general concerns which you have related to this court today?
I'm not trying to be smart, but it expressed what it expressed. I'd hate to speculate on something that exists.
Understood. The motions that the defendants filed seeking a continuance pursuant to 2906, you were not opposed to those motions, correct?
Correct.
Mr. Mulliner, in the 30 years that you've been practicing, have you ever seen another jurist conduct a pretrial proceeding and press a case to trial in this particular way?
No.
Have you ever seen a judge deny a properly filed motion under 2906 excluding the day of trial?
In 30 years of having things happen in my periphery that I may not recall at this point, it is possible, but my memory is I have no recollection of ever having witnessed such a thing. It is possible that it occurred not to me, but in my presence or view, and I have forgotten the same, but I don't think so.
I'm going to ask you a question I don't know the answer to. It's the same one I asked Mr. Goss. Is the fact that he filed a judicial complaint against Judge Boyd, is that more or less common knowledge in the Bexar County criminal community?
Consistent with what I said earlier, that I don't generally try to pay attention to something that is not directly relevant to what is on my plate. I will tell you, I did not know until we were in this case and it became a relevant fact of interest to me. So I'm probably not the best person to speak to what the community generally knows, but I was previously, I believe in 2010 or 11, the president of the San Antonio Criminal Defense Lawyers Association, and that association is active, and at least back then there was over 400 members, and they are vocal, and this would be something that would be of note to them, of interest to them, discussed among themselves. And so based on my knowledge of this core group of 400 people, I can't imagine that it hasn't been discussed up and down the hallways of this building on numerous occasions by dozens, if not hundreds of people.
About 10 minutes.
Gotcha. Okay. I'm going to ask you, I'm not going to ask you whether you believe Judge Boyd is impartial or partial or biased in this case, because that's not even the standard here. But you seem to be a reasonable man. And I'm going to ask you as a reasonable man, do you harbor doubts as to Judge Boyd's impartiality with regards to Mr. Goss or any of the people on this side of the courtroom?
I am mindful of the standard of review, and as a prosecutor, listen, not to draw unwanted notice, but we have next of kin in the courtroom. I have an exceedingly strong interest in multiple parties, almost most assuredly to include the next of kin, to not have to have a significant risk of enduring a second and subsequent trial just to get to the point of having a single conviction that could be maintained. And of course that is, it's all speculative until you go to trial, so I'm not making a prediction as to the outcome, but the way it's presently poised, I am very concerned, knowing the standard, that this is one more area that if we were to proceed to trial with the elected judge of the 187th, it is one more issue for me to have some very significant concerns about the possibility that this works or operates along with other possible factors to make a conviction, should there be one, be a conviction that is not able to be maintained.
couple of cleanup questions. You've been practicing a long time. You've been practicing as both a defense attorney and a prosecutor in front of Judge Boyd at this point. Have you ever seen Judge Boyd deny a 2906 motion properly filed before?
I have had very, very few encounters with Judge Boyd as she has been on the bench. I have more experience with Judge Boyd when she was either a prosecutor or when she was, prior to that, a criminal defense attorney. And I had very few instances of contact with her when she was the judge. This is really the first time that I've had anything significant in front of her.
And in your 30 years of experience, have you seen judges deny continuances made in good faith based on FMLA or before FMLA, just maternity or paternity leave?
Properly so. That essentially seems to me to be inviolate. Maybe not 15 years ago or 10 years ago, but you know, medical leave for the birth of a child for either the father or the mother just doesn't get torqued with, as you would hope and expect. It's given great deference.
And just last question to clarify, you're here testifying because we had served you with a subpoena earlier to this hearing, is that correct?
That's why I'm sitting in this chair. I didn't volunteer, and but I was willing to answer your questions once I saw that I've been served.
And I appreciate that, sir.
Sure.
That's all I have.
Mm-hmm.
Mr. Lennon, do you have any follow-up on behalf of the state? I do not. Have a seat, Ms. Milner. Thank you very much. What else?
Judge, that's all the witnesses we have. I know you have somewhere to be, so
Let me just say this. Okay. I've reviewed your motion carefully. I've had experience in the 187th with other motions. Each motion is, my rulings are based on the specific facts of that motion, just like the other matters we heard. And I granted those recusals, again, case specific, fact specific. In this particular case, I started off with, you know, I am the regional presiding judge for the 4th Administrative District, and my statute says my job is to make sure efficient, orderly, and fair administration of justice occurs in the 4th Region. And I cannot see where it would be fair or efficient to allow this case to go forward with Judge Boyd.
At this point, Your Honor, no, I do want to say I don't think it was admitted into evidence, but we did have significant commentary on our particular clients on Judge Boyd's YouTube channel, where there were probably over 150 comments. But
Again,
you've already made your ruling.
I'm making my ruling based upon what needs to happen in the trial of this case, forgetting about the YouTube and all the other issues involving the YouTube. This case needs proper investigation. The prosecutors need to comply with their oaths and their duties. They've indicated they haven't had that time, and I understand that. Defense lawyers need to talk to expert witnesses and get them prepared and get them here. So the only way for that to happen, it appears, based upon what I heard, is for the motion to recuse to be granted and somebody else set up that docket control order. So I will prepare an order and get it to everybody tomorrow. Otherwise, we are in recess. Thank you.
Thank you, Your Honor. All right. Hey, everybody. Thank you for sticking it out on there. We're going to go ahead and knock out a few things.